All right, we are live. So my name is Chris Berry, a certified law attorney, certified financial planner with Castle Wealth Group. We help families plan, protect, and preserve what's important. And we do these weekly wisdom webinars every week, almost every week. And we're going to start with a positive focus. So my positive focus is that had a great kind of last weekend before all my kids' activities start. So they're in soccer and swimming and flag football and just a bunch of stuff. And now it's all starting up. We're already into soccer practices. But this last weekend, we didn't have anything scheduled. So we ended up going to downtown Detroit, walking around Campus Martius, which really, they've done a great job. And then going to the Detroit Tigers game. That was Saturday. And then Sunday went to the Renaissance Festival, which is always a good time. So, all right, here's a question coming in. But yeah, so if you do have any legal, financial, or tax planning questions, feel free to put it in the Q&A and I will go ahead and answer them. And with that, I'm going to share my screen. Gotta hit a couple buttons to make it happen. And we're waiting for it. Come on, Zoom, catch up. There we go. Now we're in business. All right, so first question. My father passed away with the legacy trust. Now we need to split the proceeds between me and my two brothers. How does this work? So what it was, or what a legacy trust is in our office, it's a revocable living trust. So revocable living trust, but instead of outright distributions at a specific age, because the concern with that is what happens if the person inherits it, there's a divorce, lawsuit, creditor action, bankruptcy. Instead, what we're doing is we're leaving it to our beneficiaries in trust, where each beneficiary could be their own trustee. And now you're giving the beneficiaries the opportunity. So whatever they inherit from you, if anything, is now protected from creditors, divorce, and the money stays in the bloodline. So we call these legacy provisions. So what happens is, okay, so dad set up this revocable living trust. Now it splits into 3 separate shares. One share for each brother. And now each brother can be the trustee of their own separate share trust. So if one beneficiary wants to take the money out and be done with it and get rid of the trust, they can do that. The other 2 brothers could keep theirs intact. Really, all that's needed is 2 things. One, we have to get a certificate of trust, and then the second thing that we have to do is get a tax ID number for that trust. Okay, and if this was like, say, Jim Smith was dad, the titling of the accounts would be like the Smith Trust for the benefit of like John, the Smith Trust for the benefit of Sam, the Smith Trust for the benefit of Mike. And each would have their own certificate of trust and their own tax ID number. Yeah, and then, so really what happened is there's one intermediary step that would have to happen before it makes a split. So basically what happens is then before that split, we need a tax ID number because the trust has become irrevocable, and a certificate of trust now for saying that the successor trustee is the trustee of the trust. So there is one additional step. We have to get certificate of trust and a tax ID number. The tax ID number is basically like the social security number now of the trust. And so that's a general trust we use to wrap up all of dad's final affairs. We need the certificate of trust that says that the successor trustee is now in charge instead of dad. Once that's taken care of, and we know all the bills are paid, then it can flow down to the beneficiaries. So hopefully that's helpful. Now, let me know if there's any questions on that. All right, move on to the next one. This was actually an issue I was just dealing with right before I was hopping on to this this webinar. So it wasn't really a question, it's just like this was just happening, and this is why we need to be careful about handling the state administration, making sure we have good planning in place. Excuse me. So we had mom. Mom was not our client, and she had an IRA. So she had $200,000 of IRA money. And there's two daughters. This is a hypothetical scenario, of course. So we have my clients over here, but then a sister over here, and sister was named as the trustee and executor. Again, we did the planning for one of the daughters. Her other sister was the one who was appointed to wrap up mom's affairs. So mom had $200,000 inside of an IRA, and sister, who was in charge, and the big thing with IRA is it's pre-tax dollars. There's no tax that have been paid. Okay. So what are the options when mom passes away? The typical option is, do you need trustees? I'll get to that question. So the typical process of what would happen is that we would separate this into two separate accounts. So now we would take mom's IRA, which is pre-tax. Now we'd have two separate accounts, one for each sister, and now they could have a inherited IRA. Okay, an inherited IRA for each one. And the thing with the inherited IRA is it's still pre-tax, but now all the taxes have to be paid over 10 years. Okay? That's what the Secure Act did. So all the taxes have to be paid within 10 years. Okay? But we can stretch out the taxes. We can, if we want to, or we can take it in, or we can take it out earlier if we want to as well. But typically we would do it that way, just so that every beneficiary has their own, they can fit this inheritance into their own planning. Unfortunately, that's not what sister did. What sister did is took the money out of the IRA and put it directly into a checking account. Okay? So she took the $200,000 IRA and then put that $200,000 into the checking account. Now, can you guess what the problem with this is? The problem is that A, none of the taxes were withheld. And then B, you didn't give your sibling, who was my client, the ability to make a choice of whether she wanted to pay all the taxes or not. And so now we had to advise our client that, yeah, you're going to be getting a check for $100,000, but understand no taxes have been paid on that. So you might think you're getting $100,000, but that $100,000 is additional income that's going to show up on your income tax return now this year. So don't go out and spend that, because you're going to have a tax bill on the back end. And so we were in the process of opening like an inherited IRA account and everything, and then we just learned that the sister actually just deposited in a checking account. It's like, what are you doing? So I guess my advice is talk to professionals when it comes to these things. All right, so here's some questions. So going back to this scenario, the question is, do you need two trustees for the legacy trust? So no, we can have one sole trustee. There's additional step of taking money out of the trust, but no, we can just have one trustee. So it's not like you have to ask permission or anything like that, or have someone co-sign on different things. Now, there might be situations where we might want two trustees if we don't necessarily trust the child or beneficiary, or we might want a separate trustee other than the beneficiary if There's some special needs concerns or things like that, but typically we would have the beneficiary as the trustee of the trust, legacy trust. All right, and then this is a question that just came in. And then again, if you do have any questions, feel free to put it in the Q&A. Okay, assuming you live to 100, is it best to take Social Security? So when to take Social Security? So the question is, assuming you live to 100, is it best to take Social Security at age 70 or much sooner if you take the Social Security checks and you keep your other money invested longer to push out that break-even point? Yeah, so this is a really common question. And this is one of the things when we talk about income planning, which again, there's 5 areas that we focus on. We focus on income planning, investment planning, tax planning, healthcare and long-term care, and then legacy planning. So this is one of the key questions that we always get when we talk about creating that plan for income. I can tell you, and we run the numbers and I can show you charts and we can even run it for your specific situation. So this was anonymous, but if you want to email us your Social Security statements for you or you and your spouse, we can run the numbers and show you the best way to maximize Social Security. I think there's like 567 ways to like claim Social Security, especially as a married couple. So there's a lot of different options, but assuming you're going to live longer, the general rule is you're going to want to delay taking Social Security. Break-even point's usually about 82. If we think we're going to pass away sooner, then typically it makes sense to take Social Security earlier. Now, you might be, and there's a couple things that come up, but when you run the numbers, and it's pretty easy for us to do, if we just get your Social Security statements, we can run the numbers and calculate the actual break-even point. But the reason why, there's a couple of reasons why people delay taking Social Security. First of all, is that each year you wait past full retirement age, it grows at a guaranteed 8% plus whatever the cost of living adjustments are. Okay, there's no other investment that grows at a guaranteed 8%. Though with interest rates going where they are, like that could be wrong. Like we have a high yield savings account that's offering 5% guaranteed. So that might change in the future, but yeah, Social Security is guaranteed to grow at 8%. So your income is going to grow. The other reason we don't like taking Social Security right away is that it is additional income coming in. And right now we think taxes are one of the biggest risks and biggest opportunities. So if you have pre-tax accounts like IRAs or 401ks, we call those like tax infested accounts, like you're still in partnership with the IRS. So I would rather pull money from those accounts because A, to cover your income needs, and then B, looking at IRA exit strategies, things like Roth conversions. So if you were to take that additional Social Security, that gives you less room to pull money from these tax infested accounts because we know taxes are going up in the future. Now, sometimes people will say, well, Chris, if I delay taking Social Security, what happens if I pass away? Then I say, well, you're dead. It doesn't matter. Versus the reverse. What if you take Social Security at 62, you live a long life and you run out of money? Like that's like from a financial standpoint, like that's a worse outcome. If you pass away and you're dead. Plus, if you're married, we almost always want the higher earner delaying taking Social Security, because if they take it at 70 and the spouse who is not the breadwinner, that spouse will get bumped up to the higher earner Social Security when that person passes away. So it's not just planning for you, but also planning for your spouse. So now that said, that's just from a numbers standpoint. But again, at the end of the day, if we're running the plan and you're not going to run out of money either way, and it gives you more peace of mind to take Social Security earlier during those like go-go years to spend your money, then that's fine too. It's not always about the numbers. And that's where my undergrad was in psychology and finance. Like I know the numbers part, but also it's peace of mind and happiness. And we need to like put the two of them together. And as long as we're making intelligent choices and yeah, maybe we're leaving more dollars on the table, but it gives you more peace of mind and happiness to take it earlier, then we take it earlier. But as a general rule, if you're just looking at the numbers, it's going to make sense to delay taking Social Security. Here's a question. There's only one trustee in the legacy trust. Would it still be protected from lawsuits since the person has direct access to the funds? Yeah, the answer is yes. So there is one additional step in terms of taking money out of the trust, but yeah, you can manage it. You only need to have one trustee. These have been tested and effective. There hasn't been any problems with that. Just like when we set up like the Castle Trust, the Asset Protection Trust, we only have one trustee, and it's protected from lawsuits, creditors, Medicaid. In fact, we just had about a week, 2 weeks ago, we had one of our clients go into a nursing home, applied for Medicaid. We had set up the Castle Trust 5 years ago. And so because Medicaid has that 5-year look back period, and Medicaid actually asked to see the trust, so we had to send it in the state of Michigan, and they like rubber stamped it and approved it. So we just again had verification that this planning actually works. But I know what I'm talking about. Okay, that is all I see. All right. So thank you, everyone. If you do have questions, feel free to shoot them over via email, and we can address them on the next webinar.